Hello, it's Phillip Taylor from Richmond Green Chambers. I'm talking about an interesting academic book, The Politics of the Common Law. It's this book here. It's written by three experienced academics. Wayne Morrison, who is known to many people from the University of London External Programme. Adam Geary, who is one of my colleagues who is at Birkbeck, and his colleague Robert Jago. Now, I've written a fairly detailed, quite a high level book review of this work, and I entitled it Our Contemporary Common Law Under Serious Academic Political Scrutiny. Now, the headline itself gives you an idea that in fact this is quite a heavy book, but it gets to the heart of some of the issues we have today, because we know what the common law means. It means the law made by judges. But it always amazes me how many learners and lawyers assume that judges don't play politics, because the reality is that they do. You see it in some of the judgments, and they justify it by the words common law and policy, especially in the House of Lords. Now, the beauty of our common law system is that the judges don't do it overtly. So this book succeeds, in my view, in answering its basic question: can a revitalised common law address a plural post-colonial future? Now, of course, the answer is going to be yes and no. It can't be a strict one way or the other. But I came away with from the author's conclusion that the answer would probably be yes. It's yes because the subject has rightly been reinvented and reorientated by them, giving what we all know as a legal system or a legal method both some coherence and some foundation, which seems to be lacking, unfortunately, in the Human Rights Act of 1998, which appeared, of course, and has changed the legal landscape, probably for good. Obviously, we'll be getting an amended version of that Act in due course. Anyway, for this very reason, I welcome the book as a major statement on 21st century evaluations of the common law we have today, because our own legal system is obviously becoming more entwined with the European Union and its law and its institutions to a limited extent, and of course both global legal and financial issues, much as they have come to the forefront since I wrote this review in the middle of 2008. I was reading this book during the annual Human Rights Conference which I attended, which is run by Justice and Thomson Reuters, and I heard many speakers referring to what I see as the main theme of this work, which is an evaluation of the general jurisprudence of human rights emanating from the 1998 Act in our current common law context. Can I indicate that in addition to the Conference on Human Rights, which is an annual event, we did have Jack Straw addressing the bar, various sort of bar conference issues at a number of different events this year to celebrate the 10th anniversary of the 1998 Act, which of course he introduced. And now he's become Lord Chancellor. He's actually very proud of the Act. He's reorganised the Lord Chancellor's post, but he, as I say, whilst being proud of it, he always reminds the conferences that he's been addressing that he considers it will be one of the lasting legacies of the current Labour government. That's the one since 1997. Obviously in the three parliaments it's the singular big achievement, and certainly historically will be seen to be so by for both Blair and Brown, because it's changed the face of Britain. Now, opening this new chapter, the three authors, Geary, Morrison and Jago, recognise that the Act has created a more pronounced judicial intervention into politics, which is obviously to be expected with its review of administrative actions in the public sector in particular, since the Thatcher years. Obviously, to me, the greatest value of the book is that it places our picture of the common law in its contemporary context and reviews our criminal and civil procedures, although none of the authors, of course, are practicing lawyers as I am. However, that's a good thing in some ways, because they're seeing it from a different point of view from the one I will see as an advocate in court. I found the book highly informative throughout. There are 16 chapters on specific jurisprudential themes, each of which examines what I would look to call the pressing issues of the day, tensions between the requirements of economics and the demands of justice, and so on. Obviously, legal aid is a particularly important area with the recent anniversary of the founding of it. It's a deep book. I said that obviously earlier and indicated that you've got to have a basic grounding in legal method to understand it fully. And I certainly would advise learners to have some knowledge of our legal system before they embark on reading it. But to me, the greatest value is found in placing the common law with each of its historic links with the 4 themes that are running through the book. Let me just refresh your memory on those, and that is 1, the engagement with the cultures of post-colonial common law, the notion of judicial practices, an engagement with the notion of procedure or process, and of course human rights. Anyone will know who's been a student of law that the common law will always be born out of historic experience, and that's really how I teach it in many ways. Obviously precedent is at the forefront. So I came away from this book reminded of some of my old political campaigns, because I'm obviously a politician as well as a lawyer, mainly against the anti-European Union people within my own party. And I tried to consider the useful practical implications of the work, which will obviously open up a new chapter for all of us in this century. And obviously there are many areas for debate which this book tries to address. The authors have achieved here what I think is the forerunner of a new, stronger debate on the value of the common law in the post-human rights era. And with the long-awaited and expected green paper, which I believe is going to be called the Bill of Rights and Responsibilities, we're going to need to place the current debate in its context. And I think it starts here with ourselves, with the EU, and globally as the new century unfolds, so that some of our main legislative codes merge when the main sort of challenges of globalization on legal institutions are reviewed. Because clearly, with the growth of EU law, not the diminishing of common law, but the growth of EU law, we are getting much more of a standard approach. And I see, certainly in the next 50 years, much more global agreement on some of the basic practices. We've got a long way to go, but this is a great start, and thank you to the 3 authors. It's a great contribution for anybody in doing either undergraduate or postgraduate research, so do have a read. Thank you very much. Bye-bye.